Right now in Arkansas, there is a group building a whites-only town. In 2025, it is not a hypothetical, it's not a metaphor, it is a 160-acre compound with families already living on it, with hundreds of thousands of dollars raised, and an application that literally requires proof of European ancestry. They call it return to the land, and they claim it's completely legal. I disagree. My name is Shanik. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against big corporations or government entities that have harmed them or taken away their rights, including in civil rights cases under some of the same laws that, in my opinion, make return to the land less than legal. Now, this video isn't just about one extreme example. Groups like this exist on a spectrum. All across this country, you'll see gated subdivisions and co-ops and private clubs that have exclusionary policies. What would you do if in your own backyard or in your neighborhood there was an HOA that excluded people, screened people based on family status, based on income, based on LGBTQ status? What tools do you have? What loopholes do these clubs and these organizations use to claim that they're legal? And why, oh why, does it always take lawsuits to make real change? Let's start with the legal foundation. If you grew up in the United States or you have some knowledge of the US legal system, you may be thinking the Constitution, the Equal Protection Clause of the 14th Amendment protects you from discrimination. The Equal Protection Clause of the Constitution was how segregation was struck down in Brown versus the Board of Education. But the thing about the Constitution is generally it protects you from infringement on your rights by the government. It doesn't really protect you from private actors. For that, you need different laws. The backbone of those laws, the foundation of federal civil rights laws, is the Civil Rights Act of 1866. That was passed after the Civil War during Reconstruction. Congress said, okay, slavery is done, but we also need to get rid of the badges and incidents of slavery, the things that come along with slavery, that are repercussions of our country's history with slavery, things like exclusionary policies when it comes to housing. And that's where the statute comes in. 42 U.S.C. 1982. Section 1982 says that every citizen of the United States has the same right as white citizens to inherit, purchase, lease, transfer, sell, hold property. Everybody has the same right as white folks. That's the law. There are no carve-outs for private businesses or groups or clubs or co-ops. It is a sweeping edict on the backs of the Civil War and the end of slavery. No discrimination when it comes to property. And in 1968, when a black family was denied housing in St. Louis and sued, and it went all the way up to the Supreme Court confirmed that the Civil Rights Act makes private discrimination when it comes to housing illegal. And then you've got the Fair Housing Act of 1968. That was signed just a week after Dr. Martin Luther King Jr.'s assassination. And it vastly broadens the scope of what type of discrimination is illegal. It includes more than just race. It created new government agencies and initiatives like the Department of Housing and Urban Development, HUD. It created an enforcement mechanism for the Department of Justice, the DOJ, to enforce private violations of this law. Cases since then have interpreted the law to mean that even if there was no intent for discrimination, even if somebody didn't say, we're going to make this a whites-only town, if the effect of all the various policies in place were to actually make it a whites-only town, if it were to have a disparate impact, a discriminatory impact, even without an express intent, that also could be illegal. Part of the reason is because very often when people are discriminating, they don't do it out loud. They put into place policies that sort of as a sideways measure have the effect of being discriminatory. If you have an income floor, if you require that people speak fluent English, if you put into place requirements that are going to have the effect of discriminating people of a certain race or background or origin or family status or sex, that could be discrimination. And it would be illegal under the federal civil rights statutes. Many states have their own civil rights frameworks, laws, enforcement mechanisms that offer protections beyond the protections offered by the federal civil rights statutes. State agencies sometimes enforce faster than the federal government, and they're also not necessarily subject to the same political tension that federal administrations have when it comes to enforcing civil rights. One thing to note is that even if you are not specifically excluded from this kind of membership club or association or group, it could still affect you negatively enough that you could have standing to sue. If something like this pops up in your town, it could affect your enjoyment of your community. Loss of enjoyment is a real harm. It could also affect property values, and that is another harm that may give you standing to sue, depending on the laws under which you're suing. So how do groups like Return to the Land claim that what they're doing is legal? Well, their pitch is, we found a loophole. They didn't. They run the land through an LLC or another corporate structure, and then they sell memberships to live on the land. And so their pitch is, we're not in the business of housing or property. We are in the business of membership to a very private association. Now, there's a very important legal test that I use when I'm representing someone. I'm trying to figure out whether their rights were infringed, whether the law was broken. It's called the sniff test. And in my experience, if something doesn't pass the sniff test, probably not legal. And this, private membership associations, are not new. This has been around forever. In the 40s, it was restrictive covenants. You can't sell this house to black people or Jewish people. In the 60s, it was private clubs. It was segregation academies. And now it's private membership association. The names change, but the intent and the function and the impact stay the same. Discrimination. Now, there is an exception to the Fair Housing Act for private clubs. That much is true, but it only applies if the housing part of it is incidental. So like a church retreat or a meditation retreat, summer retreat that has cabins, maybe that is a bona fide private club. Or a golf club that has lodging, that could also meet the test. But a 160-acre compound whose sole purpose is for people of a certain ancestry or a certain background or a certain ethnicity to live together, that to me is not a bona fide private club. That is housing. And discriminating on the basis of race, in my opinion, is housing discrimination. And courts have found time and again that when housing is not incidental to the club's purpose, when it is part of that association's mission, then that does not meet the bona fide private club exemption to the Fair Housing Act. And by the way, I don't believe in legal loopholes. No, laws are drafted for a specific purpose to address a specific set of factual circumstances that exist or can be predicted to exist in that sphere. At a certain point in time, there will come along factual circumstances that fall outside of what was known or predictable. And when that happens, either the rulemaking bodies, the legislatures, amend or create new laws, or courts interpret the existing laws to expand them to fit factual scenarios that courts believe fall within the letter and the meaning and the spirit of the laws as written. That's how the law evolves. A loophole is really just a factual circumstance that a court hasn't had the opportunity to apply existing law to, or legislatures haven't had a chance to address yet. It's not a loophole. And that's why, in my opinion, Return to the Land is not betting that what they found is a legal loophole. They're not betting they're going to win in court. They're betting on two things: politics and inertia. I think groups like Return to the Land, they are gambling on the politics of the folks in charge of enforcement, whether it's a state attorney general who might not be politically inclined to go after this group and enforce civil rights violations, to the federal government, which in whatever administration it's in, may not be politically inclined to enforce discrimination against non-whites in the form of a whites-only compound. I think they're betting on politics. I also think they're betting on inertia, that individuals who may actually be harmed by this, people who might apply and who would be denied, well, those folks, A, wouldn't apply in the first place because they wouldn't want to live there, and two, if they did, they wouldn't want to go through the hassle of suing them, especially given the current political climate. They're betting on these two things. I don't think they're betting on winning in court, because it's my opinion that they wouldn't. I just don't think they would. But sometimes that doesn't matter. Sometimes all that matters is that the government won't enforce, and individuals have no reason to go out on a limb and put themselves out there to seek private enforcement through the courts. This is why private lawsuits matter, because civil rights don't enforce themselves. And you know what? A lot of times, the government doesn't enforce them either. Brown versus the Board of Education didn't happen because the government took it upon itself to enforce civil rights laws. It happened because students and the families of students who were being segregated, who were being discriminated against, decided to sue in a class action. They sued the school district, and they won. And then the federal government came in and helped enforce the ruling. But they made the law. And part of that is by design, because the federal government knows and the state governments know that, politics aside, they will still never have enough resources to be the sole enforcer of civil rights violations. And that's why these laws often bake in private rights of action. So in addition to enforcement mechanisms through HUD or the DOJ or the state agencies, they allow for individuals privately to sue under these laws. So when groups say, we found a loophole, what they're really saying is, we're betting no one's going to sue us. But history shows that sooner or later, someone's going to come along and they're going to stand up and say, this is wrong. And somebody has to do something about it. I don't know if someone's going to sue return to the land. They may not. By the way, the people who live on that compound, I'm sure they're the nicest folks on earth. I'm sure that they are good-hearted and kind and loving and good family members and good neighbors. And all those folks may live together without bothering anybody. And that'll be great. But the question is, what happens when that situation is happening in a place where there are scarce housing resources? What happens when they're happening in a city, in a town that doesn't have a whole lot of housing? It's not out in the country somewhere. It's a densely populated place, and that's the only place to live, and they say, no, you can't live here. That's when it's so important that we have these laws in place. Now, maybe Congress goes out and makes an amendment to the Fair Housing Act and says that if you're talking about a rural compound X miles away from a place with, no scarcity of housing, that's another exception to the Fair Housing Act. I don't know, but the state of the law right now, where we are right now in the law, I don't believe that kind of organization complies with the federal civil rights statutes. So here's the takeaway. If you see somebody being discriminated against, if you see somebody, including yourself, being the subject of exclusionary policies, and you think there's nothing we can do about it, you're dead wrong. The government may not enforce, but that doesn't mean you're powerless. You have got a toolbox of state laws and federal laws, and you can find a lawyer, and you can go to court, and you can assert your rights, because that's exactly what these laws provide for. It's why they were written, and it's how the biggest civil rights victories in history were ever won. There you go. I hope you enjoyed this video. Thank you for sticking around, and I hope to see you next time.